So we are now on the lesson about what is custodial investigation. So it involves any questioning by law enforcement people after a person is taken into custody or deprived of his freedom in any significant manner. So in the Philippine context, this actually pertains to the questioning carried out by law enforcement once an individual has been detained or had their freedom significantly restricted. So this process adheres to legal principles designed to safeguard the rights of individuals during police investigations. And we have right here the RA 7438, and this law was approved on April 27 of 1992. And this act defines certain rights of person arrested, detained, or under custodial investigation, as well as the duties of the arresting, detaining, and investigating officers, and providing penalties for violations thereof. So it basically outlines the rights of individuals arrested, detained, or undergoing custodial investigation. It also specifies the responsibilities of the arresting, detaining, and investigating officers, imposing penalties for any violations of these provisions. And we have right here the rights of person arrested, detained, or under custodial investigation. Here are the duties of public officers under RA number 7438. First one is any person arrested or detained or under custodial investigation shall at all times be assisted by counsel. So this actually ensures that they have legal representation during questioning or any legal proceedings, safeguarding their rights. Second one would be any public officer or employer, anyone acting under his order or his place, who arrests, detains, or investigates any person for the commission of an offense, shall inform the latter in a language known to and understood by him of his rights. So that includes the right to remain silent and the right to have legal counsel present during their questioning. So during custodial investigation, it must be very important that the individual must be informed of his rights in a language they understand. Third one, it refers to the custodial investigation report, wherein it shall be reduced to writing. So the investigating officer is actually required to create a written custodial investigation report, and this report is signed or thumb marked by the person under investigation. And certain procedures, of course, must be followed. This ensures that individuals are fully aware of the contents of a report before providing their acknowledgement. Next is, what is extrajudicial confession? Extrajudicial confession is actually a declaration made voluntarily and without compulsion or inducement by a person under custodial investigation, stating or acknowledging that he had committed or participated in the commission of a crime. So it is voluntary and spontaneous, made by an individual who is under custodial investigation, without any form of compulsion or inducement. Extrajudicial commission, it is a declaration wherein it is given outside of the formal legal proceedings or courtroom. So we have right here the requisites of extrajudicial confession. It must be voluntary. It must be made with the assistance of competent and independent counsel. It must be expressed. It must be in writing. And rights of person arrested, detained, or under custodial investigation. So this is a continuation for the fourth one. Any extrajudicial confession made by a person arrested, detained, or under custodial investigation shall be in writing and signed by such person in the presence of his counsel or in the latter's absence upon a valid waiver, and in the presence of any parents, elder brothers and sisters, his spouse, the municipal mayor, the municipal judge, district school supervisor, or priest or minister of the gospel is chosen by him. Otherwise, such extrajudicial confession shall be inadmissible as evidence in any proceeding. So this fourth one basically explains that any written extrajudicial confession made by a person who is arrested, detained, or under custodial investigation must be signed by that individual. This signing should occur the presence of their counselor. If the counselor is absent, the person can sign upon a valid waiver, but the signing must take place in the presence of any of the following. So as what I've said, the parents, elder siblings, the spouse, the municipal mayor, municipal judge, district school supervisor, or a chosen priest or minister of the gospel. So if these conditions are not met, the extrajudicial confession cannot be used as evidence in any legal proceeding. And the purpose of this is to ensure that the confession is made voluntarily and with the presence of a designated individual for support. And we have here a fifth one. Any waiver by a person arrested or detained under the provisions of Article 125 of the RPC or under custodial investigation shall be in writing and signed by such person in the presence of his counsel. Otherwise, the waiver shall be null and void and of no effect. So Article 125 basically discusses about the delay in the delivery of detained persons to proper judicial authorities, wherein if you detain someone, you should deliver them. If it is light penalty, it should be 12 hours. If it is correctional penalty, it should be 18 hours. And for afflictive or capital penalties, it should be 36 hours. And here, for the sixth one, any person arrested or detained or under custodial investigation shall be allowed visits by or conferences with any member of his immediate family, or any medical doctor or priest or religious minister chosen by him, or by any member of his immediate family, or by his counsel, or by any national non-governmental organization duly accredited by the Commission on Human Rights, or human rights of by any international non-governmental organization duly accredited by the office of the president. So any person right here who is under custodial investigation has the right to receive visits or have conferences with members of their immediate family. But we have to take note that when we say immediate family, this only refers to spouse, the fiancé, the parent or child, brother or sister, grandparent or grandchild, uncle or aunt, nephew or niece, and a guardian or ward. So this provision basically ensures that individuals in custody maintain connections with their support network and have access to necessary assistance and counsel during their confinement. So who is an assisting counsel? Well, when we say assisting counsel, this refers to any lawyer except those directly affected by the case, those charged with conducting preliminary investigation, or those charged with the prosecution of crimes. The assisting counsel, other than the government lawyer, shall be entitled to the following fees: 150 if the suspected person is chargeable with light felonies, and the amount of 250 if the suspected person is chargeable with less grave or grave felonies. So when we say assisting counsel, just to make it simple, it's a lawyer who helps a person during legal proceeding. And to continue, and the amount of 350 if the suspected person is chargeable with capital offense. So the fee for the assisting counsel shall be paid by the city or municipality where the custodial investigation is conducted, provided that if the municipality or city cannot pay such fee, the province comprising such municipality or city shall pay the fee, provided that the municipal or city treasurer must certify that no funds are available to pay the fees of assisting counsel before the province pays said fees. And in the absence of any lawyer, no custodial investigation shall be conducted, and the suspected person can only be detained by the investigating officer based on the provisions of Article 125 of the RPC. So it basically means that if there is no lawyer present, a custodial investigation cannot proceed, and the suspected person can only be detained by the investigating officer following the provisions outlined in Article 125 of the RPC. So it emphasizes the importance of legal representation during custodial investigations to safeguard the rights of individual being questioned. Here are the penalties for violating RA 7438. So if the arresting public officer, employee, or any investigating officer who fails to inform any person arrested or detained or under custodial investigation of his right to remain silent and to have competent and independent counsel, preferably of his own choice, the penalty would be a fine of 6,000 pesos or a penalty of imprisonment of not less than 8 years but not more than 10 years or both. Another penalty right here would be the penalty of perpetual absolute disqualification. It would be imposed upon the investigating officer who has been previously convicted of a similar offense, and the same penalty shall be imposed upon a public officer or employee or anyone acting upon orders of such investigating officer or in his place who fails to provide a competent and independent counsel to a person arrested, detained, or under custodial investigation. Fails to provide a competent for the commission of an offense if the latter cannot afford the service of his own counsel. Next right here would be another penalty. Any person who obstructs, prevents, or prohibits any lawyer or any member of the immediate family of a person arrested, detained, or under custodial investigation, or any medical doctor, priest, or religious minister chosen by him or by any member of his immediate family or by his counsel from visiting and conferring privately with him, or from examining and treating him, or from ministering to his spiritual needs at any hour of the day, or in urgent cases of a night, shall suffer the penalty of imprisonment of not less than 4 years, nor more than 6 years, and a fine of 4,000 pesos. And what is exclusionary rule? Well, this is a principle mandates that evidence obtained from an illegal arrest, unreasonable search, or coercive investigation, or in violation of a particular law must be excluded from the trial and will not be admitted as evidence. So it basically dictates that evidence obtained through illegal or unconstitutional means, such as an illegal arrest, an unreasonable search, coercive investigation, or a violation of a specific law must be excluded from trial proceedings. This rule is basically designed to deter law enforcement misconduct and protect individuals' constitutional right against unreasonable searches and seizures. Evidence excluded by the 1987 Philippine Constitution. Evidence obtained in violation of a right against unreasonable search and seizure. Evidence obtained in violation of the privacy of communication and correspondence, except upon lawful order of the court or when public safety or order requires otherwise. So basically, the second one refers to the protection of the privacy of communication and correspondence, emphasizing that evidence obtained in violation of this privacy is generally inadmissible unless there is a lawful court order or a necessity for public safety or order. I think the best instance or example for this, like if a law enforcement officer unlawfully intercepts private communications such as phone conversations or emails without proper authorization or valid court order, any evidence obtained through such unauthorized interception would likely be considered in violation of privacy, so it cannot be admitted as evidence in court. Third one would be evidence consisting of extrajudicial confession, which are uncounseled, or when the confessant was not properly informed of his constitutional rights, or when the confession is coerced. So the third statement is that extrajudicial confessions that are uncounseled, obtained without informing the confessant of their constitutional rights or coerced, that is inadmissible as evidence in court. So example of this would be if the police question a suspect without informing them of their right to remain silent or to have an attorney present, or let us say if the police did not inform the offender about the Miranda warnings and the suspect confesses during this interrogation, that confession may be considered inadmissible. Then the fourth one is evidence obtained in violation of a right against self-incrimination. So it involves evidence obtained in violation of a right against self-incrimination, which allows individuals to refuse to answer questions that may lead to self-incrimination. So if evidence is obtained by compelling someone to testify against themselves, it could be deemed inadmissible. So an example of this would be if a person is forced to make self-incriminating statements during police questioning, and this information is later used against them in court, it might be excluded as a violation of a right against self-incrimination. We have here the doctrine of the fruit of the poisonous tree, so otherwise known as the exclusionary rule. So evidence will be excluded if it was gained through evidence uncovered in an illegal arrest, unreasonable search, or coercive interrogation or violation of a particular exclusionary law. So if evidence is obtained through an illegal arrest, those things that I've mentioned, it is excluded from trial. Next, it is an offshoot of the exclusionary rule, which is applied to primary evidence. This principle, or the second one, means that it is somewhat an extension of the main exclusionary rule and is applied to primary evidence. Because when we say primary evidence, these are actually direct evidence or information that is essential to the case. So, an example could be if the police, in violation of, let us say, illegal search of a person's home, find a key piece of evidence and subsequently use that evidence in court, the exclusionary rule and its offshoot would potentially render both the illegally obtained evidence and any deprived primary evidence inadmissible in court. Next is, what is silver platter doctrine? In criminal law, this was a doctrine that a federal court could introduce illegally or improperly state-seized evidence as long as federal officers had played no role in obtaining it. And the doctrine was actually declared unconstitutional in 1960, with this case Elkins versus United States. So this was actually a doctrine that a federal court could introduce illegally or improperly state-seized evidence. But right now, it is not being practiced because this was considered unconstitutional. And here is an example of a Miranda doctrine. So here on the left side is the English one, and on the right side is for the Tagalog. And when it comes to the Miranda doctrine in Philippine setting, the right to counsel espoused in the Miranda was based on the leading case of People versus Galit and Morales Jr. versus Enrile ruling, subsequently incorporated into the present Constitution. And we have here the massiah doctrine. So the massiah rule was applied to the use of testimonial evidence in criminal proceedings deliberately elicited by the police from a defendant after formal charges had been filed. So the massiah rule actually emanates from the U.S. Supreme Court's decision in Massiah versus U.S. It actually safeguards right to counsel by prohibiting the deliberate elicitation of incriminating statements from a defendant after formal charges have been filed without the presence of the defendant's attorney. So let us say, for an instance, if a defendant like Mario, he faced drug trafficking charges, invokes right to counsel, and is assigned an attorney, any intentional efforts by law enforcement to elicit statements through an undercover informant after charges have been formalized could violate the massiah rule. So, yeah, in a hypothetical scenario where the police plant an informant in Mario's, let us say, jail cell to gather information, the obtained statements may be deemed inadmissible if it can be demonstrated that they were deliberately elicited in contravention of Mario's constitutional right to counsel during a critical stage of the criminal proceeding. And you have the Custodial versus Illinois case. It's a landmark case in the U.S. holding that criminal suspects have a right to counsel during police interrogation. So this decision actually underscored the significance of protecting individuals' rights to consult with an attorney in facing police interrogation. So it lays the groundwork for subsequent cases, including the Miranda versus Arizona, which solidified the requirement for informing suspects of their rights before questioning. So Escobedo's legacy continues to shape the legal landscape surrounding the rights of individuals in custody during criminal investigations. And we have Gideon versus Wainwright case. So, U.S. Supreme Court unanimously ruled that the states are required under the 6th Amendment of the U.S. Constitution to provide an attorney to the defendants in criminal cases who are unable to afford their own attorneys. So, this ruling emphasizing equal justice under the law mandated the establishment of public defender systems across states, profoundly impacting the criminal justice system and safeguarding the rights of indigent defendants to legal representation. So, Gideon's legacy actually endures as a cornerstone of the constitutional protection of the accused. And that is the end of the discussion. If you have questions, just feel free to ask me.